yazze okujja. Tuzze wano okwogera ku nsonga za ensala omusango gwawabibwa Hajjati Faridah Nambi eyawangulwa Kaluke Kawempe nga era tufunye ensala olwaleero dakiika tonnya emabega nga kkooti erangirira okulonda kusaziddwamu era ng'esaba bannakawempe badde mu Kaluke. Ekisooka tetukkaanya na nsala eyo wale tuteekamu ekitiibwa kubevudde mu kkooti era tulina bingi tuwakanyaamu tetulowooza nti eza ne dimokirasiya emabega kubanga omulamuzi ensonga zasinziddeeko zetugenda obalambuludde okusazamu okutta kwa Kawempe tulowooza nti fu mu mateeka era eteeka omusingi gwa Uganda ogwa dimokirasiya mbeera embi okugezanga bw'ogamba nti omuntu bw'aba alaba nga akalu kagenda musinga afuneyo agafuuka gajje gasambe boka olumala gagambe nti oyo agende ku kkooti nga bwe kyali so obuvunanyizibwa bwaffe era amateeka agatuweereddwa both ekibiina ne client waffe Honorable Nalukoola tugenda kusaba kkooti ekiririrwamu esazeemu ensala eyo era tugenda kukiriza tusabe kkooti ekiririrwamu eddemu obute musango bwekennenya obujulizi twatwateeka mu kkooti tulowooza nti obulamu tabwekennenya ensala era tulowooza nti bweba yekennyeza obujulizi neetuuka ne ku mateeka nanga ekiragamba tujja kugoba omusango ogwo tagenneeteereddwa mu kkooti. Olwekyo baganda bange kanso Muyizi ne kanso Luganda kanso Luganda agenda sooka atuwe kooti kanso Muyizi ajja kwogera mu Luganda ebibuuzo tuwombewope. We are here after receiving the judgment in the matter of Madam Faridah Nambi, the loser in the Kawempe North election, where court has set aside the results and it has said that people should go back to a by-election. We are dissatisfied with the court's decision, although we respect it. We believe that it is erroneous, both in law and in fact. And we have strict instructions from both Honorable Nalukoola and the party which is to appeal this erroneous decision. If we are comfortable that if we submit this same evidence before the Court of Appeal and it's subjected to fresh scrutiny as demanded by the law, and they apply themselves to the law and the fact beforehand, they'll have no reason but to set aside this erroneous decision, which we think that even state democracy aside, for anyone to say that if people come at a polling station amidst the jury, they kick ballot boxes, they tear ballot papers after people have polled, and they in otherwise disrupt the counting of the exercise like they did in this 14 polling station. And an election is overturned on the basis of that. It will set a bad precedent for democracy. Because losing candidates will be doing this unless court wants to promote this. That if you say that you're losing, you organize people to come and disrupt the counting of the election. So we think that sets a bad precedent, and court had an opportunity to condemn the violence by not treating, not rewarding the people who committed the violence with an election result. So Council Alex will give a deeper analysis of the judgment, and then Council Uganda also give a deeper, Council will give a deeper analysis in Uganda. Thank you. Thank you very much, members of the fourth estate. You walked with us this journey from when it began about 3 weeks ago to today. As I earlier highlighted by our colleague Kenzo at exactly 12:30 this afternoon, we received judgment in election petition number 1 of 2025, challenging the election of Honorable Nalukoola as the Member of Parliament for Kawempe North constituency. We would like to highlight that there were a number of allegations that were put forward by Hajjati Nambi as far as this election was concerned. The total number of allegations were close to 27 allegations ranging from different issues to do with bribery, obstruction of election officials, obstruction of voters, campaigning, and disenfranchisement. And the court has annulled this election on two main grounds. The first ground is that the non-inclusion of the vote of 16,640 as the petitioner erroneously called them affected the result of the election in a substantial manner. Secondly, that Honorable Nalukoola campaigned at one of the polling stations in Kenzo, Angola, and court, in its wisdom, found that this allegation had also been proved. So those are the only two grounds upon which the election and the will of the people of Kawempe North has been set aside by the Honorable Court. As officers of court, our number one obligation is to respect all court judgments, whether sensible or not, whether legal and compliant or not, or otherwise. Our duty is to respect. And we would like to say that as the legal team, for Honorable Nalukoola, we respect the court judgment. However, we hasten to add that we fundamentally, we legally, we factually, and logically disagree with the judgment of court because it has defied all the known legal principles. Saying it quite often, and we shall still continue to say it, that Uganda is a Commonwealth country, and we are bound by the doctrine of precedent, we are bound by the doctrine of stare decisis, and all courts are in hierarchy. So as a high court is bound by the decisions of the Supreme Court and the Court of Appeal. And we presented evidence to court on how it should treat the 14 polling stations. In the absence of evidence from Honorable Nambi, who voted, how many people voted, how many votes were. Even in one of the cases of the Court of Appeal that we have gone forward, even where we had over 2,000 polling stations, the Greater Mukono not included, the Supreme Court said that cannot aside an election. However, in the whole judgment, we have seen of 56 pages that we finished the hearing on Wednesday. In 2 days, it had read over 4,000 pages, over 5,000 pages. The court had analyzed all the evidence and been giving in 3 weeks, 2 days, and it came out with a judgment on Monday of 56. We must go on to that court. So such speed, supersonic speed, unprecedented in the history of our country. And we also encourage you to keep up this even in all the other cases that we are having. But we have not seen the reason why the judge has departed from the Supreme Court. We have not seen the reason why the judge has departed from the Court of Appeal guidance on how to deal with such a situation. Because it is very fundamental to note that the will of the people, the will of 92% of the people of Kawempe North cannot just be turned around unless they are very justifiable in the ground. And on that alone, we have instructions from both Honorable Nalukoola, who is away right now on his religious privilege, and the party to challenge this finding of court. Because against precedent without justification for departure, but it also defeats logic because there was no evidence to support that finding of court. We believe it is based on conjecture and it is based on misapplication of the law. The other ground that we are challenging is the finding of court that Honorable Nalukoola campaigned at the police station by saying Amani Gabbard, because that was the actual allegation. So that someone said Amani Gabbard and it is the finding of court and the wisdom of court that amounted to campaigning. That means Nalukoola, not Nalukoola, and that means people power. We want to say one that the court still, right from the Supreme Court, has been very emphatic that when a particular witnesses come to court and give evidence, you require some independent evidence to corroborate.